Good evening, everybody. Thank you so much for logging into this special webinar on a justice platform for India. We have distinguished guests to discuss this important concept that we as a nation are facing today. So the way the program has been structured is this is about 90 minutes. We're going to spend 90 quality minutes to discuss the perspective from the judiciary, the international perspectives, ADR perspectives, and the implementation and the technologist perspective. To give these views, we have Honorable Justice Ravindra Bhat from the Supreme Court of India. He's going to be on your panel, on your screens very soon. We have Professor Orna from Haifa University and the author of Digital Justice. Thank you so much, Orna, for sparing time to join this panel discussion. We also have Mr. Santosh Misra, CEO of Tamil Nadu E-Governance Agency, who's joining us from Chennai. Thank you so much, sir, for taking time for this webinar. So the way the structure of this event is that the first 10 minutes, we will have a few, I'll have a few slides to share on the concept of justice platform, the way we see it, we have conceptualized it. So for those who are attending the webinar of Daksh for the first time, Daksh is a non-profit civil society organization based out of Bangalore. We work in the area of judicial reforms. We've been focusing on the rule of law project since 2015. So we have been doing work on the empirical and data-based analysis of the performance of the judiciary. So we have been asking a lot of why questions based on feedback from the ground, a lot of national level surveys, a lot of data-based analysis. So if I can just take a moment. We realize that it is important to also ask why not when we're thinking of the future, right? So there is, there is now the saying that there is no evidence from the future. So there is no empirical analysis that you can do for what should be done in the future. But the imagination of what can be for the justice sector should be something that we all want to engage with. If you can just give me a moment, I'm going to let Justice Bhat enter the live session in a minute. So while interoperable systems are something that are increasingly gaining traction across the world, what we wanted to do through these white papers that we released in March was to go into reimagining the justice system as a set of interoperable functions and functionalities. We wanted the justice system to be sufficiently imagined before we go into the implementation aspect of it. And
I think we have lost you there. Your screen has frozen.
Yep, the screen seems to have frozen. We'll wait to hear.
I guess he's logged out and he'll log in again.
Yep, we'll wait for a second. I always, for those people listening in, I always say it can't be an event about technology without technology going wrong somehow. But that's always part of the lesson, right?
Yeah, and here I am actually going to advocate use of technology for delivering justice.
Yes, we all are. That's fine. We will wait a few more minutes. I'm sure the problems will be resolved soon.
Yeah, I think so. So just waiting for our host to come back online.
So maybe for our audience, we can talk a little until everyone comes on again. So I'm Orna. I'm a law professor at Haifa University. And one of the fields I teach is the connection between dispute resolution, formal and informal, and technology. So that's part of what I'm going to talk later about today. And Santosh?
And I'm Santosh Misra. I head the e-governance for Government of Tamil Nadu. So all the Tamil Nadu government initiatives on information technology for public service delivery, for epidemic management are being handled at our organization. And today it will be interesting to explore some ideas on delivery of justice, so using technology. And with Professor there and with Justice Bhat leading us, I'm sure, and Surya has done a lot of research on delivery of justice in India. So I think we'll all benefit and learn, and also we will exchange ideas and see how going forward we will have better justice delivery system for the country. So here he's back. Welcome back.
Right.
We had a short discussion.
Can you see the screen?
Yes.
Is the presentation visible?
Yes.
Yes.
Okay. This is just going to take a few minutes before we go right into the topics. In the Indian judiciary, the digitization has been there for quite a few years, but formally as two phases, it has about to end. The second phase is about to end this year, formally. It has been the digitization so far has given us a solid bedrock on which we can build further. The phase 2 has given us computers in almost every court hall, printers, network across the country on a separate wide area network. So this is a solid foundation for us to think further on what transformative things we can achieve through digitization and technology. The problem, however, has been that the digitization has been more front-facing, in terms of the court case data being made visible to the citizens. But the functioning of the judiciary itself has not made much use of technology. So the filings are still paper-based filings, and therefore all the subsequent activities are completely paper-based. And because of this, the citizens continue to have to use whatever old and outdated processes that are currently being followed. And what processes that were designed in the past for paper-based processes are still guiding what can be done on technology. The one way to reimagine the future is to say, how can we use a platform approach for the justice sector as a whole? What is a platform approach? This is a very, very good overview on what is a platform. Platform is really an infrastructure on which you build services It's like roads. It is like a cable wire. It's like your Wi-Fi network, right? On which you build services. It is essentially enabling rendering of services. But the base of all this is there has to be a uniform data registry, especially for something like the judicial. And another important factor for all this is, like for roads, you have standards on how roads should be built. There needs to be an independent oversight to ensure that there is that the services are built on responsible use of data. The way we have imagined the justice platform is through 4 principles: modularity, open standards, open data, and privacy. Modularity is really at the core of how a platform works. There is no forcing down of a solution to anybody. Open standards will enable building of modules that speak to the needs of each specific stakeholder. It could be police, it could be prisons, it could be government authorities who interact with the judiciary for responding to cases or other stuff. Each group has its own needs and tasks. Modularity enables this customization, which can speak to so many different kinds of needs. Really, how modularity is achieved is through open standards. Standards is basically the platform is built using a consensus on how modules will function, will be interacting with each other, and the way the standards are set is important. It has to be transparent. It has to be representative of all stakeholders, and it has to be really open, as the word suggests. It can enable citizens, governments, private sector players, all the market forces to interact with this justice platform by developing their own solutions for their own needs. Along with open standards comes open data, right? When there is a technology platform as robust and as widespread as this, there is a need to ensure that there is accountability and transparency in the functioning of the platform. A big way to do this is to make sure that there is open data on its functioning. It really reduces asymmetry of information from across stakeholders. Who are these stakeholders, right? Clearly, at the forefront are the citizens. You have judges and court staff, you have lawyers, you have police, you have forensic labs, everybody that we know of. And most importantly, as we are seeing, there are government platforms and ADR. What should the public platform achieve? For somebody who is stuck in the Indian judicial system where cases take a long time, inordinately long time, efficiency seems to be the first thing that it needs to achieve, which can help cases move faster. Privacy is something that it can be achieved. Security, transparency, accessibility, multilingual capability for differently abled citizens, lawyers. How can the justice platform be more accessible? It is possible to do so in an approach like this. Most importantly, coordination between agencies, right? Just like how we spoke about government agencies not able to get a response, get a notice to a case or responding to a notice, there is much to be achieved through coordination between agencies. All of this can be achieved through a legal backing of how this platform should be working. There needs to be a legal backing for how the platform will function. We need to give justiciability if we are going to move online to these procedures. There also needs to be a legal backing for how the standards need to be set, and for the privacy. Privacy is a very sensitive topic, and it's a much wider topic than what we can cover today. But just to give you a sense of what really should be the guiding principles of privacy when it comes to judicial data, this is the framework that we have put in. There are sensitive case data in some cases, names of litigants, names of the accused parties, maybe witness names to ensure that they are not harassed. Then there are people who should not be given access to certain case information, who should only access it for their functioning and not beyond. So there are non-judicial fiduciaries and other organizations who need to be given access only to certain types of information of the judicial data, without going into bulk access and case-by-case access that certain citizens need for their own matters that are going on. This is the last slide, really. I won't take much time. These are the questions that we see as something that needs to be discussed and debated, and for which we hope this panel discussion will throw more light on process reimagining. Reengineering was a word that we have been toying with, but really reengineering to me sounded very incremental. Can we reimagine processes in this technological era? Can we do having process reimagined, the new way of doing things? Can we roll it out so to make sure that there are no errors and there are really no downsides to what we're thinking about? Interoperability of modules, how do you ensure that? How do we ensure that they're not leading to any further inefficiencies, right? We believe that there are solutions that need to be used, that are solutions that are being used in other sectors that can be customized for the functioning of the judiciary and the justice sector. Finally, most importantly, stakeholder involvement and change management, so that really the change that we're bringing about is non-reversible, the change that we're bringing out is sustainable, and we can go ahead and reach further heights in this process. So this is really all that I had for today, and I'm just going to go back to the panel in a bit. Please give me a moment.
Surya, is it possible to put the slides in a full screen view? That's a couple of requests from the audience.
Yeah. Sir, good evening, sir. Justice Ravindra, thank you so much for taking time to join this webinar. I'm so sorry there was some delay from our side in letting you into the panel discussion.
Good evening.
Right.
Hello.
So, Professor Orna is the other panelist, and Mr. Santosh Misra is also here with us, sir.
Hello, sir. Good evening. Great to have you here, sir.
Thank you. Thank you.
Sir, we can dive right into your welcome comments and the opening remarks. So the way we have structured is the next half an hour to 40 minutes, each panelist will make some opening remarks, and then I have some questions and I will respond to some of the points that they make, and then we will open up the floor for audience questions. Audience, please type your questions on the YouTube channel where you're watching this broadcast. Please identify the speaker to whom you're addressing this question to, so that we can take it up with them. Justice Bhat, thank you so much for coming. Please, sir.
Yes, thank you, Surya. When we are looking at the current pandemic and what the kind of transformations it has accelerated, I am not saying this is brought about, but it has accelerated the use of technology, and most visibly the audio-visual technology. So we are seeing one end of the spectrum. We have not yet worked out the details of how to integrate all the other systems. So in my opening, I would only say this, that the pandemic gives us an opportunity not only to look at technology, but also see whether we have to replicate courts in everything that we do in the courts today. Perhaps this is, I mean, and I'm conscious of the fact that we have an expert who's written a lot about ODR and its feasibility, etc. How is it possible to kind of replicate that at a at certain levels, and this is where I tread with caution, because I do not see that certain kinds of disputes which are of low volume, low value, but large in volume. And this could be, we have seen experience in England has shown that certain monetary limits, disputes with up to a certain monetary limit, are given to these online courts or online decision makers, who then typically walk through the process with the litigants. We also have the experience of WIPO, and then of course the ODR platforms, which are basically B2B platforms where disputes are in bulk and the decision is dictated by some kind of algorithm. So these are all the kind of available models for us. Now, post this, when we are riding through this pandemic, we see the urgency. The courts in India, and I'm sure across the world, and I read some time ago, there's a common website where we could see the progress of digital courts and video courts across the world. So across the world, they are adapting to existing technology and adapting to newer technology, and trying to ensure that life goes on, and disputes and courts which provide some kind of essential services continue to function. Now, how much of this is to be integrated as we go along when we come back to whatever semblance of normalcy, and how much of it needs to be discarded in the sense that we go back to the old system, so-called old system, is something which has to be first debated. Now, side by side, along with that, there is a lot of talk of AI. AI and its potentialities in predictive, algorithms which take care, which are able to forecast the likely decisions or likely outcomes having regard to past patterns. Well, they all have their merits, especially in large volume disputes, in disputes of a certain kind. They have been deployed even in decision making, especially in brief review and so on and so forth. But there are issues with that, and one can briefly kind of lay it out. These are based on repetitive AI algorithms, and predictive coding is based on past patterns of behavior. In the judiciary and even in the legal field, document review and brief review, that is in court cases, building up responses to queries based on specific set of facts, resulting in creation of algorithms which enable the computer to process huge data dealing with similar tasks, is the key to machine learning. Many law firms in the West employ these programs. Many companies have developed them, and they have increasingly sophisticated uses. Essentially, they are based on patterns of past behavior. Well, so far so good. So when we look at large volumes of cases, large volume where masses of documents are typically filed in large arbitration claims or construction engineering disputes, or even patent disputes, where you're looking at numbers, you're looking at document crunching, facts, etc. These are, I'm sure these are hugely useful, and this is a way forward. But when you come to normal run-of-the-mill cases where the decision maker has to take a call, the patterns of behavior based upon, let's say, structured data. The structured data would be in the form of decisions which are already available. According to me, there is no algorithm as yet has been developed which takes care of outliers, which takes care of the hidden biases. And there are obvious hidden biases. These are limitations. For instance, hidden biases based on gender or other inarticulate premises would be just reflected in these algorithms. One example is the patterns of statistical data, such as the likelihood of certain kinds of offenders based on age or crime, criminal misconduct being repeat offenders. These kind of outcomes based on this predictive coding can lead to horrifying, outcomes, because they can gravely affect grant of bail or even sentencing and so on and so forth. Therefore, I would tread with caution when we talk of use of information technology wholesale. The legal and judicial systems the world over have embraced or have been driven to embrace technology in varying degrees. Tools of investigation in criminal cases, search of databases in patent claims or anti-dumping proceedings, production of voice, audio, and digital evidence, etc., have increasingly been resorted to. Going further, post-COVID, I would, looking at the present trend, see a greater acceptance of the use of technology, and also greater attempt to arrive at some form of paperless courts. Court-related services such as digitally signed or authenticated judgment copies, digitally enabled service of summons, and so on and so forth, which you just spoke about. There is likelihood of greater efficiencies, such as limited arguments, precise written submissions, efficient use of time, which will benefit judges and lawyers alike, such as specific time slots for hearing, etc. Integration of data in the entire judicial system, whereby data sharing is possible from the trial court onwards to the Supreme Court, again leading to tremendous efficiency, cost and saving, and importantly, accuracy of information are immediately foreseeable gains. Other important gains would be vastly reduced paper usage, which is environment friendly, ease of use by litigants and law alike, elimination of paper. In the present context, guaranteeing safety from contamination are the immediate benefits. The important concerns that have to be addressed are data security, which you mentioned, ensuring full-time privacy of case documents, easy steps to e-filing and scheduling of video hearing, 24/7 data safety, keeping it safe from corruption and hacking, retrieval, easy data retrieval, and at the same time also ensuring that the data is kept in a format which does not render the elements inaccessible due to technological obsolescence, etc., are the challenges which every court system, every country has to address. And this is a continuous thing. It's not a one-time thing, because metadata which is available would have to be seen in the contemporary formats which are used by courts, which may undergo, transformation time and again. In disputes which are of a private or interpersonal character, several modes of dispute resolution exist, which are arbitration, conciliation, where there's an element of consensual decision making. India also has its own brand of alternative dispute mechanism, which is a kind of conciliation, which is Lok Adalat. And then we have, as I said, online dispute resolution models, that is B2B, and the WIPO models. India is known for its innovation and solutions in the software industry. With our experience in Lok Adalat, mediation, and these traditions and other forms, I am sure that our unique solutions to resolving disputes can be explored from a new trajectory. For instance, all cases which end in penalties, and we have seen that increasingly in some states where traffic penalties are virtual courts, etc. Cases involving some summary procedure in the criminal procedure code can be made over to online courts, while ensuring safeguards in the cases where some form of sentence is to be given, in which case a hearing should be given. Use of audiovisual aids in the cases, certain kinds of cases involving technology, intellectual property, complex crimes, anti-dumping competition, or corporate disputes, or white-collar crime, which involve a web of financial transactions with several entities, should be liberally encouraged. This is where technology should be liberally encouraged to speed up understanding and decision-making in courts. Courts, after all, are institutions which guarantee justice based on fair procedure. We no doubt have to reorient ourselves while retaining the essential values of fair procedure. And also, whatever procedures that we do have in the Indian context or talking of any other context, they have to be in tune with the cultural mores which have informed each nation. We have a certain model of courts which have ensured traditionally liberties, which are guaranteed to our people. Now, technology should not be so disruptive as to undermine those essential and eternal values which our societies cherish and are based upon. So therefore, any attempt to completely, subsume the existing courts with and substitute them with technology-based courts should maybe we should not embrace it wholeheartedly. We would rather have to tread in with caution. That's my introductory remark. There was one small query which I think I was asked. If you would like me to address it, I can do that at this stage or later on the interoperable.
Questions at the end. So
Beg your pardon?
So we can come to the questions at the end when maybe you can address two, three questions
at
at one time.
Yes. So there, I was asked to speak also on the interoperable criminal justice system.
Right.
The ICJS. As I understand, the ICJS is more of a data sharing platform, which is to aid where you have information in relation to arrests, persons in jail, the nature of offences, past conviction of individuals, stages of trials, links with institutions like forensic laboratories, etc. Now, this is the remit of your the present ICJS system. The website indicates that some hundreds of police stations and about 5 forensic laboratories are interlinked. As I see it, it is information and data sharing, which ideally should speed up investigation. And yet, unless complete details are available and presented to the court about some of this information, such as, for instance, past criminal misconduct and facts relating to it, mere statistical data. Now, this is where I would sound a warning that presenting a mere statistical data about some person who has behaved in a certain manner in the past without full details can be very dangerous. Why? To the extent it aids police in investigation, such an information sharing is good. I'll give an instance. For instance, if one is accused of a crime, the usual facts surrounding the incident, such as who witnessed it, the area where it occurred, when it was reported, the credibility and reliability of witnesses, expert opinions, etc., have to be produced after due examination. Now, for these reports, the institutions, especially forensic laboratories, are woefully inadequate in terms of capacity in India. And I speak entirely of India. They're insufficiently staffed, more often than not overburdened to the point of being overwhelmed. At times, samples are not examined for years together. Therefore, the attempt should be to strengthen these primary institutions. Data information and data information sharing has to be there, and more as an investigative tool rather than presenting it during the trial, because unless full data about a particular trial is available, chances are that accused and those accused of crimes and who are defendants in criminal cases would be shortchanged. There would be a presumption. So this is where my reservation would be. As far as the expansion of the platform for criminal trials is concerned, well, there have been pilots in England. There's not much empirical data, but one thing is definite, whatever I have read, is that going further, when it comes to certain parts of a criminal trial, perhaps one can look at information technology as a model. One can think of it as a solution. But certain parts of the process, like for instance, depositions of key witnesses, statement of the accused and defendant, and the hearing of arguments by the judge, these I think as at present should continue the way it is, because we are fundamentally looking at deprivation of liberty. And the look and feel of the proceeding has a humanizing effect. we should not rob unless technology is sufficiently sophisticated that you reached it to the point of approximation of reality. Robbing the one liberty that an accused gets his day in court would be a travesty of justice, looking at the kind of technology we have at present. And then there is crucial elements like sentencing and looking at the demeanor of witnesses, etc. These are, as I understand, these are not possible in a video court. So I feel that having an ICGS which enables powerful investigative tools to police and other agencies across the country is a good idea, as long as they present these in a full and fulsome manner. But if you get them into a kind of a video court and expect them to perform solutions, I think it would be too optimistic. Thank you.
Right, sir. Thank you so much. I think that note of caution is much required in this day and age when there seems to be Professor Orna, could you please comment based on your experience in other countries and your work on technology in the justice sector and the platforms?
Sure, thank you. Thanks for having me. And this was such a rich, two very rich presentations that have really made my talk much easier. So I'll try to relate to some of the things that came up. What I'd like to talk in the next few minutes is about court online dispute resolution, as we call it in my field, ODR, which is an acronym that of course resonates ADR, which is alternative dispute resolution. For many in our audience, I'm assuming, at least in the audiences I know, it's true. For many people, the combination of courts and online or video conferencing seemed to be a new one that was introduced in the last few weeks and months as we're facing the biggest pandemic we've known for a century. And the truth is this is actually not a completely new development. So what we call court ODR has been around now for almost a decade. And the sources of court ODR, online dispute resolution, are actually rooted outside the court system, outside the public domain, and they are from the e-commerce setting. So ODR started out as the equivalent, as I said, of ADR in the field of e-commerce in the mid to late 90s. And what happened was, not many people know this, but it was actually not allowed to have commercial activities online until the mid 90s. And as the ban was lifted and communications began to expand and they were over money, disputes soon followed. That's natural, I guess. And these disputes had really no procedural outlets for redress, because these disputes were typically, they were between strangers, often across borders, different languages, different legal systems. And it wasn't feasible to meet, not in a courthouse, not in a mediation meeting room, not for conciliation or arbitration. And so some form of alternative needed to be provided, and there were commercial platforms that had the incentive to create that in order to generate trust and to have people want to continue to shop and relate to one another through their platform. And what they did was they looked at what's out there, negotiation, mediation, arbitration, and tried to mimic, replicate that online. And we're sort of saying, you know, it's not the same, it's not as good, but it's what we have. And when we have a procedural vacuum that we need to fill in, we might prefer this to nothing, right? So even if they sort of accepted the fact that remote online communication was inferior. And so they allowed for the communication, but they said, you know, it's never going to be as rich as face-to-face communication. It's never going to be as secure. And there were these various disadvantages that were discussed. But most people said, you know, because these are small scale, low value disputes, not emotional, that this could work, and indeed it had worked and expanded dramatically. But over time, the meaning of online dispute resolution changed. People came to view it differently. If initially it was viewed as online avenues mimicking traditional ADR processes to fill in a vacuum and provide dispute resolution for online disputes, it came to be understood more broadly. And this happened for several reasons. First, technological capabilities expanded, and we were no longer limited to replicate what was offered offline. And as you said, Soraya, early on, to reimagine. So people started reimagining and embracing the qualities of technology and said, hey, we can actually think of different types of processes that couldn't be handled face-to-face. So diagnosis emerged. I can say a word about that later. Automated negotiation emerged, where the parties are negotiating, but the software is a sort of conciliator. It's not neutral. It does some things. It's not quite AI, but it does do some in the way that a human mediator might have done in a room, okay? Crowdsourcing was possible. All kinds of alternatives started surfacing. Another important change was that people no longer viewed it as only possible for online disputes. And this was happening because the whole line distinguishing online and offline was shifting, right? So if it used to be that in the early days when I was studying this field, we talked about the $100 laptop, and online was connecting to the internet sitting by your computer. Nowadays, many people who don't have a computer connect all the time. They walk around with their phone, right? And they're online, offline, alternatively. And they're discussing things they wouldn't have thought they would discuss online in the past, right? And they're interacting with people and businesses that are often nearby, and they could walk over physically, right? Or have some kind of physical interaction. Sometimes I'm embarrassed to say I interact with my own family when they're in the next room, right? And we send a WhatsApp instead of getting up and talking to one another. So this whole distinction of what's appropriate for online, what we prefer to do online, starts to blur. And it starts seeming plausible to think that we would also resolve online disputes that emerged face-to-face. And the public sector comes in here. And for the courts, this was a real opportunity to address the deepest problem courts have faced for a long, long time now, the access to justice problem, right? So courts' procedures have been critiqued for being too complex, too lengthy, too costly. Professor Susskind, I just heard him yesterday say, they are designed by lawyers for lawyers, right? So many people have difficulty interacting with the courts. And the question was whether these processes could offer something in terms of increasing access to justice. And the interesting thing here, I think, is we've always assumed, and that's part of our thinking, that there is an inherent trade-off between efficiency and fairness, and I would say between access and justice, right? So if we're increasing the efficiency and maybe even the access of proceedings, that might come at a cost to fairness or justice, at least when we look at that face-to-face and think about the elements of due process that are involved in a process like that. And once we stop seeing technological options as inferior and actually embrace them and think about the unique qualities of digital technology, not as a panacea, certainly with caution, certainly with great care about design, we can identify opportunities for increasing both access and justice. It doesn't mean that every online process would do that, far from it. But it means that with careful design, and if those same values we discussed that have always existed, right? That we heard before, that have to guide our way in the legal system, can continue to serve as such guiding lights, are injected with different ways of fulfilling those goals and values. We might be able to do that through technological means. Why is that? Basically, when we offer online proceedings, we are experiencing three shifts. The shift from face-to-face meetings to online interaction. And while we're all bombarded with Zoom and various other video conferencing applications, actually the ODR field has focused a lot on asynchronous written communications, okay? So a lot of the tools developed there are very different. They're not trying to replicate a hearing or a meeting, but they're actually trying to get at the same goals from different aspects. And what we find is, at least with respect to asynchronous communication, is that it greatly enhances access. Language presented to people can be much simpler. You can access 24/7 from the comfort of your home in pajamas, right? Without having a babysitter for the kids, without taking time off for work. All of these opportunities are open to us. It also allows us not only the comfort, but some kind of empowerment by not having to address a judge or another form of authority in real time. Think of the stress, especially for disempowered people who belong to disempowered communities, of being in that setting and having to address an authority figure. Something about the remoteness might make it more accessible, might make us more willing to participate, might give us more comfort and a sense of security. A second shift we see is from relying solely on a third party, human third party. That's what we typically call the person who is assisting in resolving the dispute, could be a conciliator, mediator, arbitrator, or a judge, to a fourth party. So it doesn't mean, I'm not, like you, I'm skeptical of AI in terms of decision making, but the technology is there and is operating in conjunction with a third party. In some examples, we see it substituting, not in courts, but I agree, in very limited context. But this opens up a lot of opportunities in terms of access to justice. Firstly, obviously, in terms of capacity. You know, when we talk about eBay and Alibaba handling 100 million disputes a year, eBay 60 million, 90% of which are resolved only with the assistance of automated negotiation, no human mind and hand involved. So this is pretty much unfathomable and provides access to people who could not have been dealt with if we only had human assistance. Aside from this capacity and some would say efficiency related issue, there's also a potential for increasing fairness through the machine. And what we see in these ODR applications that are available in some courts is that parties receive written language that's very simple, is addressed, you know, to people who have not studied for many years, and their legal situation is translated into everyday language, opening up options and a better ability to understand their situation and how to progress about it. And this is tailored to them. They are being asked specific questions, and according to their answers, they receive instructions. And the fact that the software is suggesting languages, presenting options, can be, I'm saying it doesn't have to be, but can be, under appropriate, careful design, can be something that levels the playing field for a party who wouldn't have been aware of such options. In another case, I heard of software that blocks an option for negotiation for parties who owe a debt and are actually subject to protection. They're not supposed to pay that debt, but they're unaware of it. They don't know what their legal rights are. So, of course, maybe it would have been ideal to provide them with top-rate legal assistance, but the reality is they're not going to get that legal assistance. And then the software can actually guide them and tell them more about their situation and have a safe negotiation that protects their rights. Just an example. And the last shift is from small data to big data. So We haven't been great admirers of data in the dispute resolution field, certainly not the alternative, which rightfully places a significance on confidentiality. But even courts have not been great collectors of data and studiers of data. And what we're seeing now is a huge opportunity, especially with online dispute resolution that's based on written communications. A lot of data is captured. And what this means is huge in terms of fairness and justice, I think. For the first time, we're able to really study the implication of procedural choices on particular parties, how they impact and shape the outcomes that they receive. When do parties of X gender drop out when the process is structured like that? And what happens if we change a certain element? What happens if it's a default to one direction versus a default to another direction? So all this can be studied and analyzed in a way that really, I think, can open up our minds to the impact of system design on the outcomes we want to achieve in order to realize the values that the system needs to deliver. It also allows us something I think you may want me to talk about later, is to understand what the sources of disputes are and study them. So all these changes have brought ODR into the courts in the recent decade. In the US now, there are many dozens of state courts and county courts that employ either Matterhorn or Modria software. The dispute types range from traffic, as was mentioned, and small claims, probably the sort of more likely candidates, to neighbor disputes in the Civil Resolution Tribunal in Canada, to family disputes in the US and the Netherlands, to motor vehicle disputes in Canada and in Singapore. So all over the world, many, many courts are now employing and applying a very, I think I agree with what was said earlier, a very cautious, tailored, slow-paced approach in recognizing what the context is and should be for applying these tools. Also recognizing that this is not an all or nothing solution. There can very well be hybrid tools that involve face-to-face and technology in different phases of the process. They are also recognizing the significance of technological choices made, the design of the different proceedings used. For example, I just completed a study with two colleagues on traffic cases handled online by Matterhorn in Michigan in the US. And our study showed there the cases have shifted from an informal hearing face-to-face to a sort of informal written asynchronous process, at the end of which a judge renders a decision. And while we found certain disparities in outcomes along racial lines and age, so younger people and Blacks in the US, there were paying higher fines in those cases face-to-face. These were eliminated with the shift online. And so we're talking about biases. Obviously, there are also biases, we know, either in the human decision-making or also embedded in the structure of the traditional process. So maybe for those people, having to show up in court in real time and deliver an answer was something that was constraining for them, and they perform less well than they did in a written communication. But again, that was written and not video. And I think maybe the number one lesson that we're seeing from the other courts, and I'm going back to what you said, Soraya, is the need to reimagine and not replicate where we do introduce technology. The idea is to harness the potential of technology where it can increase access to justice, but to leave in place those aspects of the process that work and work well, and there will always be a room for having a traditional hearing. Oh, you're muted. Soraya, you're muted. Sorry.
I have a few follow-up questions on the great points. A great line that I like from Professor Suskin that you referred to is our processes need not be as old as our principles. Right? I find that just a fascinating thing when we are at this cusp, at this point of time. Mr. Santosh Misra, over to you. You have a few slides to share, I think.
Yeah, thank you, Surya, and really it has been an honor and privilege to be here. Thank you, sir, Justice Bhat, sir, and thank you, Orna, for such a beautiful and enlightening presentation. So here is my take, and it's more from the field, what I call ground level view, and this is how I perceive what we are able to achieve. Just a second, I'll share my screen. So, is it visible now to everyone? Surya, is my screen visible?
No, so I'm trying to see there are no screens shared. You need to add it. It will come up below the panel. You will need to add it as one of the items.
Okay, just hold on. Let me just retry that. Okay. Oops. Yeah. Okay. So now you should be able to see this.
Yeah.
Am I visible? Is my screen visible?
Yes, sir.
Visible?
We can see your presentation, sir.
Okay. Good evening, and this is just a disclaimer. These are not the views of Government of Tamil Nadu. These are my personal views. Here is I'll start with the Sustainable Development Goals, and one of out of 17 goals is peace, justice, and strong institutions. And I really like the idea of stating it very clearly: leave no one behind. And I think this is, I believe that this is the objective we are trying to address or achieve through technology and just using technology in justice delivery. The Hague Declaration, Justice for All by 2030, it had 5 points, which said put people and their legal needs at the center and solve people's problem, improve their journeys. There are 2 more, and what I summarize this as is first one refers to barriers to physical access, second one refers to barriers to justice processes, and the third one is basically talking about technology adoption. There are 2 more which it said. This is prevent justice problems and use justice for prevention. So that was essentially ADR mechanisms and mediation and arbitration, and provide people access to service and technology opportunities. So which I look at it as an opportunity in justice delivery system. And wherever there is a problem, there is a huge opportunity always lurking behind it. That is my firm belief. And I see the same thing happening here. And I think the Supreme Court has already taken the lead. They started with legal service authorities, which was essentially an approach to take the justice to the rural communities, to the disadvantaged sections of society. Arbitration, mediation, and ADR, and e-filing is something which they have started, and I think that's something which is going to be a game changer. I'll talk about it in a while. So, Corona has a silver lining. I think Justice Bhat was referring to it, and Orna was also referring to it. What Corona has done has brought in certain behavioral changes. So things which we were not accepting it so readily, things like physical meetings were always prioritized over the virtual meetings won't even cross our mind. And this behavior change has been a significant achievement in breaking and demolishing some of the major barriers for use of technology in this space. These major barriers have been broken. I have seen there was a huge resistance in several government organizations of using technology. There was a fear. There was always a change brings in fear. Change brings in uncertainty, and this has been demolished to a large extent. I know the High Court of Chennai. We have been trying to help, and a fantastic visionary Chief Justice A.P. Shahi, and the technical committee head Justice Sivgyanam. They have been really leading from the front. And actually, I know that for last 2 months, all the High Court hearings were held over video conferences, and an amazing amount of leadership is on display. Not only this, they have actually approached us and said that can we introduce these solutions in the district courts, and we are actually arranging about 300 licenses for the video conferencing solutions, a good advanced video conferencing solution for the district courts, so that the delivery of justice can happen from the district courts as well, using these technology tools. So while video conferencing is only one aspect of it, this corona has also develop trust in technology, and it has. I think the closest which comes to my mind is when the demonetization happened, a huge amount of behavior change which was observed. So this India was predominantly a cash economy, and after demonetization, I think a bulk of people today, on UPI, almost 1 billion transactions happen every month, if my memory serves right. So from a totally cash-driven economy to a lot of online and digital economy, that change has happened. This behavioral change is also happening during this crisis, and which is a great thing for introduction of technology. As I was referring to earlier, what are the access hurdles, access issues, and what are access opportunities? So there are physical barriers. I mean, Supreme Court and High Court are in a particular location in a state or in the whole country. And now through this video conferencing solution, for example, I mean, these courts are literally at the doorstep of the people. And this, even though it may sound very insignificant, but I believe this is transformational in terms of productivity, in terms of efficiency, in terms of transparency. As Orna was saying, I mean, you can be it has another aspect, which is of being comfortable and being able to present your case from your own settings where you are comfortable with. And, you can hear your lawyer arguing the case. You can read subtitles. I mean, the technology is transforming and changing so fast. There is a real-time subtitles which can be translated into any language you like. The argument can be happening in the court in English. If you are a litigant or you are a party and your lawyer who's arguing your case, you can see what he is saying in your own vernacular language. And this brings amazing amount of transparency. Lot of behavior which is non-transparent obviously gets wiped off. Language barriers, so physical barriers you can take care of. Language barriers, again, as I said, real-time accurate translation and transcription. There's a recent tie-up between supposedly rival companies. Microsoft and Google have come together to actually lend their heft to natural language processing. And I think that natural language processing is going to transform the judicial landscape. I mean, it will transform all the technology landscape, but I think particularly in a setting where a lot of arguments are passed, a lot of language is used, I think it is going to be a very, very impactful transition. Process barriers is, how do if I want to write a petition and file my case, can there be AI tools? Can there be tools which can actually, I just narrate my problem and it interprets the whole thing and converts it into a high court compatible or high court acceptable format, or district court, or for that matter, civil judges court, if it can convert it into a format which is acceptable to the court, and it can be filed on my behalf. Does it? So, I mean, a huge amount of, as I said, transparency and efficiency will come in if you have and this also is a great opportunity for startups. They can actually come up. There was a talk, Justice Bhat sir was saying about the data, and Orna was referring to big data. In the beginning remarks, Surya was mentioning about open data. If we have this and we encourage startups to actually experiment with some of these grand challenges, if you will, it will be an amazing opportunity in terms of economy, in terms of efficiency, and in terms of justice delivery to people. People can just use their mobile. It can be a simple app. Just speak up your problem, and out comes your petition in 5 minutes. And then you can just email, transmit it. And as I said, e-filing, even though it may look somewhat small first step, but I think it is transformational. And this can feed into your petition is ready. You can just file it and go ahead. You don't really need an expensive mechanism to actually be able to fight your case or file your case in the High Court or the Supreme Court or the lower courts, whatever it may be. You don't even have to know the language. You don't even have to be literate. I think this is mind-boggling. I mean, I'm very convinced that this is something which can actually bring in a total transformation of justice delivery system in this country, and for that matter in other countries as well. Again, the ADR mechanism is also very easily, as Orna was saying, I mean, ODR is kind of an ADR where you the online disputes are mediated by the software. And I think if you have an AI arbitrator, she was saying that right now it's more of a rule-based arbitration. If you can actually feed in a lot of case laws and actually develop a mechanism which is an AI arbitrator for that matter, or AI mediator, you can actually start delivering. And I'm so happy to hear Justice Bhat speak and say that we really need to think out of the box. We really need to reorient, is what the word he used. If we do that, I think this is fantastic opportunity. In India particularly, you have this India Stack, which I call India Stack, is basically UPI, which is a digital payment gateway. You have Jandan, which is bank account, Aadhaar, and mobile number, 1.3 billion phones. BharatNet is the ambitious project of the government. I think half the states have already implemented it. It's connecting every rural area with 1 Gbps link. Now, that is transformational. Now, if you want to use, this is the right time to actually design our systems and carefully curate them to make them drive on this highway which is being created and on this stack which is created. India is a data-rich nation, and I believe the future belongs to those who have data. And this is, I was very, in the recent WEF forum, Yuval Harari was talking about data and data colonies, and I think we are uniquely placed and advantaged from that perspective. If we talk about Tamil Nadu specific opportunities, we have some more enabling technology platforms which the government is creating, which is one of them is State Family Database, which is an integrated platform where benefits to the citizens will flow from a unified system, and we are building on top of that a blockchain backbone which enables each household to have a digital wallet which has safe and there was, just as Bhat was referring to privacy and security of data, we completely there cannot be anything much more sacrosanct than that, and this blockchain backbone hopefully will enable that. And anything which is consent based, if an individual wants to deliver a particular certificate or a particular document or a particular land record over to the court or over to judiciary or over to any other authority, they have an opportunity to do that, for which they don't have to really physically run around and get things done. AI and blockchain policy for government, and this is something unique. I think Justice Bhat was referring about biases, outliers, and threat of being profiled by intelligent systems. So this is why this artificial intelligence policy we have prepared, and it is in the government under consideration. If it comes out, one of the cornerstones or one of the keystones of this policy which we are building is ensuring that data protection and privacy and bias is taken care of before any AI solution is rolled out in the public domain. Same thing we are doing for blockchain policy also. There is one more step which the government is doing is called predictive service delivery. So why do people really have to go for small things to the government offices? A child is born. Once the child is born, we of course have a very good antenatal care system. So 99.99% births are captured with pregnancies are captured in the system. So once we know that the baby is born, why can't we actually do all the things which have to be done by the government? So immunization has to be done, Anganwadi enrollment has to be done, Aadhaar enrollment has to be done, school admission has to be done, her name has to be added in the ration card. Why do somebody have to spend one whole day, travel from his or her district, from her village to the taluk headquarter, find that the person who is supposed to add the name is missing today, and then go back after spending, so a total loss of coming expenditure, going expenditure, whole days lost. So why do you have to do that? Since the government system already knows that the baby is born, since we know that she is 3 years of age, why can't we automatically, based on the consent, allow the family to add her name into the ration card? Something as simple as that. There are,
if I may just say, 2 minutes more for your opening.
Yeah, I'm done, almost done. This is my last slide. Basically, while it sounds very promising, there are huge challenges on ground. There is a drought of tech resources. I think the way we are trying to work out in Tamil Nadu is to actually support the court ecosystem with e-facilitators. So we hope to give 2 e-facilitators in every district court who will be actually in charge of all the technology initiatives and support the district judge or the judicial officers around him, along with his team, to help this. We need to leverage a lot of startups in developing many of these solutions. And India is full of such talent. If we need to grow these grand challenges, organizations like Daksha, Ashoka University, Plaksha University, all these are new kind of universities which actually work on the intersection of law and technology. And there needs to be a core team in every high court of people or experts hired possibly from the market who understand this. This is how we have built up our capacity in Tamil Nadu E-Governance Agency. We have a center of excellence where we actually hire people on contract from the market who are expert in these areas, and that's how we drive these technology changes in the government. I think that's about it. So these were some of the things I wanted to share. Thank you for being patient and listening to me.
Right. Fantastic points. I think the practical considerations on implementing this at a ground level, I think that only somebody like you who has led emerging technology initiatives from the public sector, he can comment on that. I'm just going to collate a few questions that are appearing here and direct them to the respective speakers, and a few of them are here. One, this is to Justice Bhat, and I think a question that will keep coming up whenever any question of judicial reform is involved, and more so when it is technology, is how do we handle change? How do we do stakeholder management? The bar associations, the senior advocates. How do we? Another great quote from Professor Saskin is, how do we change? Can we at all change the wheels of a moving vehicle? Right? That's a fantastic imagery that it's stuck in my mind. So your thoughts on that? So you're on mute, sir. If you can please unmute yourself.
Yes, I'll answer that straight away, but just give me half a minute. Before coming to that, we'll also have to outline some challenges. Right. Mr. Misra did mention that we have a large number of mobile phone users.
We seem to have lost.
Frozen, I think.
Yeah.
Oh, now it's back. Okay.
So we lost you for a bit. If you can just repeat the last minute.
Reload. Yes.
We can see the. We can see.
See the smartphone.
So while we wait, Justice Ravindra Bhat to come back, Orna, a question that has come up is, how do you design or control for biases when you're designing something like an ODR, which can have all the players here? Any learnings from international experience on this?
Yeah, well, I think one sort of message is really to be careful about over romanticizing the current situation and remember the existing biases and problems in our courtroom. Of course, that doesn't mean we don't need to strive to improve. We should. I think that the solution is to understand, and I think that came up in your presentations, Raya, as well, that design is not I'm sorry, I'll pass it along. I'll just say design is not a one-time project. It's cyclical, and we collect the data and we learn about it.
Right, right. So please carry on, sir. Oops. Did we lose you again, sir? So we seem to have lost you again, sir. Orna, please continue. The design was
Okay.
Interesting.
Sure. So in terms, I think we should disconnect the question of AI from here. Maybe now it works.
Yeah, please go on. Orna, please complete your point.
So I would disconnect the question of AI from judging from afar. I think those are two different questions. And in terms of judging from afar, I think there's a lot we can do in terms of learning from the data over time, what works best in terms of by studying. It also means we need to collect data we're not collecting today many times about demographics that would allow us to discern bias. It also, discerning bias on an objective level is not does not substitute the need to ask people about their experiences. So we would want to also know how different sectors and groups in society experience different proceedings, and whether they feel more fair, but objectively, we might find that they fare worse, that their outcomes are worse, which is another, sort of ethical question we want to ask about the proceedings. Do we look at a pure sort of statistical objective outcome, or what weight do we give people's personal experience? We want to hope they go hand in hand, but they might not, which is an interesting question. I think we might need to ask.
Right. I think that's a fair point. So, sorry, you got interrupted. Please carry on.
Yeah. Before I come to that, I'll just take half a minute on the issue of exclusion, which is, I think, very important, because we are looking at introducing a technology which is going to disrupt the hitherto well-known method of functioning of courts. Not that it was the perfect one, because access to justice is always a challenge which the courts have to face on a continuous basis. Now, the barrier of technology is not just that, we have these wonderful programs, and Mr. Misra laid out a lot of them. From an optimistic angle, they can be wonderful. But the point is, how much, we have to look at the population, how many people are in a position to avail of these services. Because according to me, the outliers here are very important. Who are the outliers? Those who are challenged, physically, those who are marginalized, and those who cannot access these because of the existing barriers of language, because of large volumes of people not being literate, and certainly larger number of people being uneducated. So I think so we should not look at any reform in according to me in a piecemeal manner. Information technology is not a magic wand which will wave away and kind of take away all our problems. We have to also, as you said, and I think one of you quoted Professor Susskind, the why is very important. The why of certain procedures, how to make procedure simplified. It's not just language. I mean, we are still using language which was contemporary 400 years ago. Why is there a need to do that? Why can't we make over those changes? Which and after all, the language of the courts is not our language; it's an alien language. So when we are looking at simplifying our language, we have to see it from the prism of the court language, which is English. How simple is the English that we use? How simple is the court language which is used for an unlettered or very a man with limited education to say what he wants to say and get a pleading? How difficult or how easy is it for someone to dictate with the aid of these wonderful AI tools a pleading which he can file and ask for a small claim before the court? So these are some important challenges we have to be aware of. Now that would be part of the change. Now looking at change from my angle or with my limited experience, I would say that in this particular aspect, the question of change is extremely important. Many process and jobs, firstly, would be rendered redundant, and likely a large number of individuals connected with the court system would be left jobless, most probably in their middle ages. This and the attendant disruption has to be factored in. Policymakers have to ensure that obsolescence does not exacerbate human suffering. The second is that disruptions caused by change at individual levels should be adequately anticipated. Practitioners and litigants must be given sufficient time to absorb and implement change. Now, change management, at least when it comes to policy in India, has been very painful. And I'm talking with my limited experience as a judge in fiscal economic matters, and the latest one being GST. Mr. Misra, mentioned about demonetization. Whatever disruption it caused and whatever upheavals it caused, at least the courts did not have much occasion to see. But the upheavals caused by the GST regime, which is entirely based on technology, have been quite formidable. We have seen at any given point of time for about a year and a half, there was something like 50,000 to 1 lakh cases pending in different courts only on one issue of transitional credit. So it is important that this kind of change, when you're going to look at change, you have to take and assimilate all stakeholders' concerns, educate them, re-educate them, take their feedbacks, run dummy, what shall we say, projects, collect data, run pilot. Most importantly, I would say run pilot, projects in different places, because we have different cultures, legal cultures in the country. And then depending on the data, come out with the architecture. And then in the second phase, you will have to educate lawyers and litigants about the use of it. And according to me, one huge benefit which technology can use is that you can actually ramp up legal services. The things that Professor Orna mentioned about advice, or Mr. Misra saying that, somebody goes and says that I want to do this. This is the kind of thing that you can actually fund the legal services much more, who can have a wider variety of services online, who can give advice as well as provide legal services. And depending on the kind of problem, they can also facilitate ADRs or ODRs or whatever are the other solutions, rather than enabling people to go to court. So these kind of solutions, which will be ancillary to the court system, is as essential as access to the court, because you are looking at the larger concept of access to justice, so that to inform the litigant of his choices, so that he makes an informed decision, is, I think, vital in this. So that would be my observation on, managing change.
Starting with pilot projects and testing them out, I think that nobody can have any two opinions on that kind of an approach. Orna, you want to add anything further on the design things, or you were able to complete your point?
No, I think there are a few inspiring projects out there. I think one of the most impressive places to look at is the Civil Resolution Tribunal in British Columbia and Canada. Their motto is that the level of English, that's the main language spoken there, that you need to go through the system should be 6th grade language proficiency. What they say is they have a lot of telephone advice that goes along with the system, and it's actually freed up more time for them to assist the people who are in need of assistance over the phone. The system does a lot of the things Santosh mentioned earlier. It draws information from the parties with very simple questions. It can actually create forms and letters they need to create. So very interesting to see what they're doing. They started with a lot of opposition. It's just this Bhat indicated from the legal field, from the lawyers mainly. They started with very small disputes that wouldn't be interesting to the lawyers amongst us, and then started to expand. Now they handle motor vehicle.
Would I be right in saying that all these transformations have happened more on the civil dispute side, and the criminal dispute side are really and may need to be, right? Like how Justice Bhat pointed out, the criminal disputes will need to be handled as a separate category, and civil possibly could go ahead faster, much faster, right?
Interestingly, now I've just been writing a paper on AI, and interestingly, in AI, the opposite is true. I think a lot is, there's a lot of use of risk assessment tools. They're not decision-making tools, but they do influence decision-making. While on the civil side, it's mostly from outside the courts, using prediction-like tools and the like. But in ODR, you're right, mostly civil and family. And then some traffic. I don't know how some would say some of traffic is a bit different, and very light criminal, quasi-criminal. In Michigan, they have like an outstanding warrant case, someone who didn't show up, didn't respect the legal order. So it's on the border, but very light.
Right.
I'd only like to say this.
Why the civil codes first test the waters? Sir, you were saying something.
I'd only say this, we need not look at all these tools as solutions in the courts. After all, these are part of the system, which means that if there is a crime, and there's a white-collar crime or something which concerns, let's say, a large conglomeration of companies, a corporate, web of crime, which is complex in its nature, or let's say when you're doing a numbers crunching in terms of masses of millions of documents in a construction arbitration, or something like that, when you're doing a tax search on let's say transfer pricing or something of that kind. AI tools can be extremely, they can reduce time, they can actually promote efficiency, and at the first level of decision making, especially in tax refunds and some of those typical things where there is repetitive, there can be algorithm based. They can suggest, they can give suggestion, there can be suggestive of solutions to the decision maker, which can be efficient because they drill deep into the documents and the web, the database, and they're much faster than the human interface. So there's always a room for all this. But the question is, at which can it be end to end, or is it at certain parts?
Correct. The final question to Misra sir, I think you may have touched upon it, but in the Indian context, something of this scale or something as transformative as this, what challenges do you foresee, and how do you think, from an implementation perspective, on the technology side or the design side? Any thoughts on that, sir?
Yeah, I think Justice Bhat was absolutely right when he talked about change and the way to handle it. And I completely agree with what he was saying. One is that, of course, any change is painful. And coming back to your imagery of a vehicle moving and you're trying to change the wheel while the vehicle is moving, you can't really change wheels of a vehicle which has only, say, four wheels. But if you have a 52-wheel vehicle, which is more like our country, you can actually, while it is rolling slowly, you can start looking at possibilities of changing one and then another one. The change is always painful, and it's always so. As I said, I mean, one of the points I was trying to highlight is this: Corona has given that change. I mean, I was referring to demonetization. It actually brought. I was a heavy user of cash, and I was not sure whether. And the reason was that I never used credit cards for the fear of cloning. That was the basic problem I had. And after demonetization, I was forced to use it. I was still not very comfortable. And then the solution like Samsung Pay came along, where it actually generates a virtual card number, and you don't really hand over your card ever, and it's hidden by another. So I am saying all these changes and all these concerns are. I mean, of course I'm a hardcore optimist and a believer in technology. So I'm coming from that background, and by training also I'm an engineer and all that. But I'm saying that the solutions are initially, while it may be a painful solution, like just now we had this, Corona has given another behavioral push to our way of functioning. And I think if there is a good leadership from the top, I think the changes can be overcome. That's the hurdles can be very easily overcome. And I have had a tremendous positive experience of working with the Madras High Court. I think so proactive, the Chief Justice and the technical committee of 8 judges, amazingly proactive, saying that let's implement this technology, let's bring in this technology. And I think this is an opportunity for us to make that transition, or at least start that transition. And this e-filing, the movement, and I have a great faith in NLP. I think this India country is so diverse. I mean, we are almost like a mini Europe, or rather larger Europe, not mini Europe. So once we have this language barrier, which Justice Bhat was also referring to, if people can actually speak on their devices and just get things done, it's amazing. I mean, my in-laws, they are like 75, and they do Google search by speaking onto it. I mean, and not really a tech-savvy people. What Orna was referring to is we are developing a small software, which is an NLP-based chatbot, which is native in Tamil. So it's not really a translation from Google, but it's a native Tamil processing with the help of Anna University. They have been researching on it. The idea is that once persons find, I mean, we did a very interesting study why people are not doing online application for community certificates or nativity certificates or pata transfers. We commenced a study with IIM Trichy, and they came back to us saying that they still find it very difficult. So I said, okay, can they answer questions? So now we are working on a system where it will just ask a question. And if the person answers that question, it will compile all that information, generate a form which is acceptable to my system, which is acceptable to the government system, and say, can I submit this form on your behalf? And you say yes, and an SMS comes and you enter the OTP or whatever, some authentication, and then the thing is pushed through. Sorry, a slightly long answer, but this is the time to do it, and this is the way to do it. And with the kind of leadership which the Supreme Court is showing, and the respective high courts are showing, I think this is the time to do something significant in the judicial justice delivery systems in this country.
Absolutely. As somebody rightly mentioned, the stars have aligned. So we need to make the most of this situation. There is a inherent need that everybody is feeling to use technology and the trust in technology. And there is a global acceptance now that justice can use technology extensively in the justice system. But I think the point that Justice Bhat made about being slow, being cautious, testing it out, making sure nobody is excluded, I don't think anybody can have two opinions on that. On that note, thank you so much, Justice Bhat, sir. Orna, Mr. Sir, thank you so much for sparing your time. Wonderful discussion. Looking forward to continuing the discussion over various other forums. Thank you so much.
Thank you. Nice to meet everyone.
It was a great learning experience. And Orna, we will be connecting offline, and I would definitely request you to share some of the writings you are doing. And sir, it was a pleasure and honor to be with you, sir. And I would be really honored if there is anything we can do from here. Of course, we are trying to work with Madras High Court under the leadership of Justice Shahi. If there's something where I can be of any use through Surya or something, I'll be happy to do it, sir.
Thank you. Thank you.
Thank you so much.
Thank you. A pleasure to meet everyone and an honor to be here. Thanks for having me.
Thank you.
Everybody watching this broadcast, the recording will be up on YouTube very soon. Do write into us with any follow-up questions and we'll see how we can answer them. Have a good evening. Bye.
Bye.
Thank you. Thank you.
All the best.